Hello and welcome back. In this lecture then, we're going to look at what the terms of our contract might be. So we've established all the building blocks. We've got offer and acceptance resulting in agreement, we've got consideration, we have intention, we have the correct form of contract. But what actually is in our contract? Well, terms of a contract can be express and they can also be implied. So we need to have a look at both of those. First of all, express terms. Well, if it's an oral contract, then any term that's been negotiated between the parties will be part of the contract, at least theoretically. But you do have those evidentiary issues, remember, of trying to prove what exactly was the agreement between the parties, and each side might remember the contract slightly differently. If it's a written contract, at least we've got evidence, we know what the terms were. And remember, if it's a written contract, all the terms of that contract are incorporated, even if you haven't read them. So be very careful what you sign. Sometimes, though, you might get a written contract, but it isn't really clear what the contract is. Now, the law says that for a written contract to be valid, it must be pretty clear. The terms must be what we call substantially complete. Now, it doesn't mean everything has to be in the contract. You can leave certain points to be decided in the future, but you need to provide a mechanism in the contract for deciding how that will happen. So, for instance, you may agree to sell gold at the quoted exchange price for gold on a relevant gold exchange. That's fine. You may agree to sell a piece of land at a price to be determined by an independent arbitrator. However, a contract that says, well, yeah, we'll do this contract on the usual terms, that would be too vague. That wouldn't amount to a binding contract. What if certain terms were discussed sort of before the contract was entered into? That's quite difficult, isn't it? Because at some point you would treat those discussions as being just part of sales banter, part of negotiations. But at some point they might actually amount to terms of the contract. Imagine the statement here: if you buy this car, it will do 70 miles per gallon. Now, if you make a statement like that and you go ahead and buy the car on that basis, is that term a part of your contract or not? Well, it can become part of your contract, and the courts will look at a number of tests to decide whether it is part of the contract or not. They'll look at the special knowledge of the party who makes the statement. So if that was a mini dealership, you might assume that that mini dealer would know what the miles per gallon of the car were. If it's just a private sale between two individuals, perhaps maybe he's not quite so knowledgeable. How much time passed between the making of the statement and the time of the contract? So for instance, if I make a statement like that about my car and then 3 weeks later you come back and buy the car, it's pretty unlikely that that statement will be a term of the contract. However, if I make it immediately before you sign the contract to buy my car, it may well be a term. The courts will want to know why you didn't put that term in the contract. If it's a written contract particularly, well, okay, you had these negotiations. If this point was important, why didn't you record it as a term of the contract? And then finally, the importance attached to the statement by the various parties. Imagine you come to my car dealership and you tell me that you are looking for a car that will do at least 70 miles per gallon. You say you're not interested in buying any car unless it will do at least 70 miles per gallon. Now, if you've made that statement, then you've attached a lot of importance to it. You've therefore promoted that point about the number of miles per gallon the car will do so that it should be capable of being treated as a term of the contract. So the courts will look at all of those tests and they will decide whether a particular statement is incorporated into the contract. Now that is important because if it is a term of the contract, then if the car doesn't actually do 70 miles per gallon, you will be able to sue for breach of contract, which will entitle you to damages for breach of contract. If that term wasn't actually part of the contract, then you might still have a right of action against me, but this time your right of action will be for misrepresentation because I misled you. I induced you to enter into that contract because I told you that this car was brilliant. It did 70 miles per gallon. Now that's fine, you've still got a right of action, but the damages in misrepresentation are not quite as good as the damages for breach of contract. So ideally, you want that statement to become a term of our contract. Now, usually, if you have a written contract, that's it. And oral evidence won't change that. However, in certain circumstances, if one of the parties can show that the document wasn't intended to cover all the agreed terms, then you might be able to claim breach of contract for an oral term. And the lead case on that is the SS Ardennes case. You probably realised the SS Ardennes was a ship. And the defendant entered into a contract to deliver the claimant's cargo of oranges. And the contract said, very widely drafted, by any route, directly or indirectly. But, and this is important, the claimant wasn't happy with that, and he asked the agent of the ship owners to give an undertaking that the vessel would sail directly from Spain to London. Obviously, he wanted his oranges to arrive in tip-top condition. The ship didn't do that. It went via Antwerp, and the oranges arrived late. Now, in this case, the court said, although there was a written contract, there was also a verbal undertaking, and that amounts to an additional warranty, an additional term of the contract. And therefore, we'll treat it as if it's incorporated into the contract. The ship owners were liable. Now, in addition to terms that are actually stated in the contract, we do have some further terms that are implied into the contract. So even though they're not referred to, they don't appear on the face of the contract, they could still be relevant. And the way those terms can be implied is listed down here. So first of all, by custom. Now, custom is something, the ongoing practices in a particular industry. And so long as there isn't anything in the contract that overrides the custom, it's fine for the parties to assume that any customary terms are implied into the contract. Statute could also vary a contract. It implies certain terms, for instance, under the Sale of Goods Act. Things like goods must be fit for purpose. Goods must be of reasonable quality. These terms are implied into a contract from the Sale of Goods Act, and therefore they will be treated as if they are a term of the contract. Different to custom, though, because a term that's implied by statute can, and often will, override any express terms of the contract. Now, in certain situations, the court will also imply terms into a contract. And they'll either do that because it's necessary to imply terms into the contract to make the contract work. The parties must have intended this term to be in there, otherwise the contract would be nonsensical. Or because it's necessary to the proper operation of the contract. So let's look at the two cases here. The first one is the moorcock, again a ship. And there was an agreement that the moorcock would be moored at a particular wharf whilst it unloaded its cargo. It was known that the ship would have to rest on the mud at the bottom of the sea during low tide. However, it was assumed that that would be safe. However, it turned out it wasn't. The ship was damaged when it rested on the ground, and therefore the ship owners sued the wharf owners. And the court said, yes, in this situation there was an implied term that it was safe for the ship to rest on the mud at low tide. Another case there that's quite interesting, Liverpool City Council v Irwin. So in this case, Irwin was a tenant in a tower block and he was being sued for non-payment of rent. And he said, well, I'm not liable for non-payment of rent because under my rental agreement, which is a contract, there must be an implied term that I will have safe access to my property. Because he said there was a lot of things wrong with this property, but particularly the lifts didn't work and the stairs were unlit. Therefore, he couldn't actually get access to his flat. Although there was nothing in the rental agreement that covered this point, the courts agreed that there must be an implied term that the City Council would maintain these common parts of the building. Therefore, the tenant would have safe access. So again, make sure you're aware of those implied terms into a contract. So the final section that we need to look at is this rule called privity of contract. Now, the rule for privity of contract is that only someone who is a party to the contract can actually enforce any rights under that contract. So if we look at the following two diagrams, you'll see what I mean. Now, let's imagine we have a contract between A or B. Okay, now A has employed B, who is a builder, to build an extension on Granny's house. Okay, now the contract is between A and B. Therefore, the only person who can take any action under that contract is A and B. Okay, therefore Granny, even though she might actually be having her house extended as a result of this contract, has no rights under the contract whatsoever. And that situation isn't changed even if Granny's sort of known and discussed as part of that contract. If A and B agree to provide these goods to C, unless she has provided some consideration under the contract and is a party to the contract, she will have no rights under the contract. Now that could be a real problem, because what if the builder makes a mess of the contract? What if he messes up Granny's house? Well, it doesn't matter. Although Granny suffered the loss, she has no right to enforce the contract against builder. Also, A, who does have a right to enforce the contract against builder, wouldn't have suffered any loss, so would be unable to claim damages. So this privity of contract rule can create a problem. But the basic point, you must be a party to the contract before you have any rights. But there are some exceptions to this rule, and it's just worth being aware of these. One of them, the Road Traffic Act. Now, you take out an insurance contract with your insurance company. That is a contract between you and your insurance company. But if you crash your car and damage someone else's vehicle on your way home tonight, then that third party, that person whose car you've damaged, will have a right to make a claim against your insurance company, even though they're not a party to that contract. And that's okay, because the Road Traffic Act says it's okay. Another situation is what we call agency agreements. This is where someone called an agent enters into a contract with a third party, but actually the contract isn't intended to be between the agent and the third party. The contract is actually between the principal and the third party. Now, agency is something we'll look at later on, so we don't need to worry about that here. Another example is the executors of a will. We've seen a few examples of that already in the notes, where once a person has died, the people who are appointed to administer his estate will stand in the shoes of the deceased person. So although they weren't a party to the original contract that the deceased entered into, they are able to enforce it. And then finally, we have something called the Contracts, Rights of Third Parties Act. Relatively new Act, 1999. And what this contract says is that a third party can enforce the provisions of a contract, but only if the contract says that he can, and also if the contract makes it clear that he was intended to have the right to enforce it. Okay, so that would apply to people who are already in existence, who are named in the contract, but you could name maybe your future children. They don't actually have to exist at the time you entered into the contract, but so long as they're mentioned in the contract and it's clear that they should have rights under it, then the Contract Rights of Third Parties Act says that they will. Okay, now another question for you to have a go at. Pause the recording, read through it, and then we'll compare our answers. So in this question, we're advising Catherine about whether she's created a contract with David. So David advertised a table and chairs for sale in a local paper. Catherine saw it and offered £75. So what have we got there? We've got David advertising a table and chairs. That's an offer. Actually, that's a difficult one, isn't it? It could be an invitation to treat because it's an advert. It could be an offer. In any case, it doesn't actually matter, because Catherine saw the advert and telephoned David offering him 75. So that's either an offer coming from Catherine or a counter-offer in response to David's original offer. More likely probably an offer from Catherine. David offered to sell the table and the chairs to Catherine for £80. So at that point, we have a counter-offer coming from David, and she accepted, so we have acceptance. 2 days later, Catherine rang David and said she'd give him £85 if he delivered the table and chairs as well. Well, that's a new offer. But don't forget, we already have a contract, so it doesn't detract from the original contract. David refused, and Catherine said that if she had to collect the table and chairs herself, she would only give David £75. During the course of their negotiations, Catherine and David have discovered they know each other through the local gardening club. Well, that last bit there, that's a bit of a red herring, isn't it? They're trying to make you think about intention to contract and social and family relationships. That's not relevant. The fact that they are sort of negotiating a contract isn't changed by that particular situation. So what have we got to do? Well, as Catherine and David are acquaintances, they cannot form a binding contract. Is that true or false? Well, we're pretty sure that's false. We've already said why. The second one then, Catherine and David have not formed a valid contract as they've been able to come to an agreement about price. Well, I think that's false as well. Sorry, I should put false around there. That's false as well, isn't it? Because we can see that there was an agreement. There was an agreement there at £80. We had offer and acceptance at that point. Therefore, we have a binding contract. Third point. Delivery is capable of constituting sufficient consideration for an increase in contract price. Well, that's absolutely true. That would be consideration, wouldn't it? Providing something extra in addition to the original contract. Now, there's evidence for that here as well, isn't there? Because Catherine was prepared to pay an extra £5 for delivery. And then part C, if David accepts Catherine's final suggestion, there will be a binding contract between them at a price of £75. Well, that one's probably the hardest of these four questions. We already have a contract at £80. At £80. So if David were to accept this final price of 75, that wouldn't be a binding contract because he would be giving up his rights under the previous contract and he hasn't received any consideration for that. So this last question is again false. Okay, and that takes us to the end of Chapter 1 and Formation of Contracts. Have a look at as many questions as you can. Make sure that you can get your head around it, get to grips with it, and we'll see you again for Chapter 2.